Hello and welcome. You're watching Raj Sabha TV and I am Amritanshu Rai. This is Constitutionally Yours, a program which makes an attempt to demystify the Constitution. And joining us in this endeavour, we have Justice Akil Qureshi, Judge of the Gujarat High Court, nominated by the Chief Justice of the Gujarat High Court. We have Mr. H.D. Vyas, Secretary Parliamentary Affairs, Government of Gujarat, nominated by the Speaker of the Gujarat Legislative Assembly. And we have Amiben Yajnik, Spokesperson of the Congress Party and Advocate, nominated by the Leader of Opposition of the Gujarat Legislative Assembly. We'll be discussing the functions of the executive and powers of the executive. Also in the audience, we have law students from the Gujarat National Law University. Straight away, starting off with Article 106 and Article 195. This is for MPs and MLAs in that order. It reads, member of either House of Parliament shall be entitled to receive such salaries and allowances as may from time to time be determined by Parliament or by the Assembly. Now this is the law. Now the implication is that the MLAs and the MPs, both of them have power to determine their own salaries, their own perks, their own emoluments. And that is what we will be discussing this time. How proper or how just or how correct is it for individuals to set their own salary, and that also where public money is involved. Ma'am, straight away coming to you, ma'am. The recent case, 400% hike by the Delhi government relating to salaries and emoluments of its MLAs, which means it took the entire salary from 88,000 to 2,10,000 per month. And this is inclusive of all. Is this the right way to go ahead, ma'am? If you have the powers to set your own salary and perks and privileges, you go ahead and really shower yourself with the golden shower.
See, generally when you're talking about allowances, salaries, pays, you have some commissions, you have a proper authority to decide, committees to decide. Now in this case, when you're talking about 400% hike by the Delhi government, they had an internal committee that decided how much salary should be given to each MLA sitting in Delhi. And suddenly they came to this huge sudden hike of from 88,000 to 2 lakhs and something. Of course, they justified by putting it in several heads that it should be for office expenditure, it should be for personal travel expense to the constituency and so on and so forth. But we have to look at what the constitution framers, why they put this by way of an article in the constitution. It was as a token sum, you know, for the person to have his expenses in the capacity as a member of that particular assembly. And so he had to shell out some money, and for that he needed a salary, and that was put by way of a token sum. Well, after 1954, when the act came, there was a fixed sum of rupees 3,000 which was set by the Honorable Prime Minister at that time, Mrs. Gandhi. And then thereafter it was also made pensionable. But you have to justify, that is the situation today. There should be a committee who would look into it, whether this hike or whatever hike it is by 4% or 40% or 44% has to be scrutinized by that committee.
Or 400%.
Yes, or 400%. It has to be scrutinized whether they need it. But in today's times, why people are raising their eyebrows, that's such a huge hike? Because people think that they are not only doing the work as an MLA or as an MP, they also have some side business in them. That is a perception. And so that is why they think that they don't need so much money. They are here for public service. They should take the money which is a token sum and only required for the purpose of working as a member, not beyond that. But you are going to ask for all kinds of emoluments, you are going to ask for all kinds of monies which a salaried person is asking. He is in a different capacity altogether. And so equating them with that position is not proper. And so other parties definitely, when this Delhi government hike came, they raised their eyebrows and they said, well, this is not done, it's exorbitant. You can't have so much money from without any public scrutiny also, and from the public exchequer as well. So I think it was not justified by the Delhi government. It is not justified, and it should be absolutely reasonable. It has to be under scrutiny. Of course, it has to be adequate.
Mr. Vyas. आपके यहाँ भी काफ़ी पैसे बढ़ाए गए हैं वैसे?
नहीं, ये बात नहीं है। हमारे यहाँ तकरीबन 10 साल से कुछ सैलरी अलाउंसेस में बढ़ोतरी नहीं हुई है। हमने कुछ एक्ट में अमेंडमेंट नहीं किया है और हमारे पास एक स्टैंडिंग मेकैनिज़्म है। हमारे पास विधानसभा की एक कमेटी है, सैलरी एंड अलाउंसेस कमेटी। उसमें वो कमेटी में सब पार्टी के मेंबर्स वहाँ होते हैं और डिस्कस करते हो और रिकमेंड करते हो और उसके बाद वो जो रिकमेंडेशन पे गवर्नमेंट एंड हाउस उसको डिस्कस करके तय करती है क्या करना है क्या नहीं करना है। मगर आइडियली कहना है कि गुजरात में जो आप सोचते हैं, हमारे यहाँ एमएलए को 69,204 रुपीज़ पर मंथ मिलता है और मिनिस्टर को पर मंथ 74,420 रुपीज़ 28 रुपीज़ मिलता है। ये हमारी सिचुएशन है। यू कैन कंपेयर दिस अमाउंट विथ अदर स्टेट ऑल्सो। सिंस some 12 years we have not hiked anything, we have not taken we have not amended all these things etc. But ये जो पूरा परिक्षेप में हम चर्चा करें तो some reasonable is required. It is for the house itself to decide the reasonableness. But recently I have to say one thing. विशाखापट्टनम में कुछ 2-3 महीने पहले ऑल इंडिया वेब्स कॉन्फ्रेंस का मीटिंग हुआ था। उसमें फ्रॉम द ऑल स्टेट्स ऑल पॉलिटिकल पार्टी के पर्सन्स वहाँ मौजूद थे। वो राज्यसभा थे, लोकसभा के भी थे और वहाँ तय किया गया था कि देयर शुड बी सम कमीशन लाइक देयर शुड बी सम हाइक एंड दे ऑल unanimously डिसाइडेड टू हैव सम रीजनेबल सैलरी एंड अलाउंसेस। दैट इज़ द सिचुएशन।
मतलब प्रोबिंग शुरू है कि कहीं ना कहीं एक ऑल्टरनेटिव सिस्टम का व्यवस्था किया जाए। ये मैकेनिज्म जिसमें कि गोल्डन शावर मैकेनिज्म है, इसको कहीं ना कहीं रेगुलेट करके दूसरी व्यवस्था शुरू की जाए। सर, यू वुड लाइक टू ऐड समथिंग टू इट?
Mr. Rai, judiciary cannot have any opinion on this aspect, but stepping aside a little bit, as long as there is some scientific basis for increase, because the prices have increased. The inflation is, you have to keep pace with that. If you want to remunerate a person who is devoting his full time to public service, there has to be some basis for periodic increases. An outside commission, like a pay commission for central government, state government employees, could be one way of looking at it. It is not possible to say that a person should work without full remuneration. Perhaps the questions, it's not a just matter of spending some money after them. These questions are raising in the mind of the people because they feel that for having done all this, they are not putting back full requirement of their duties. If the parliament were to function full time, if there were no deadlocks, if every minute is being used properly, perhaps people will not even ask these questions.
Correct.
Much greater or graver issues are facing the country when a parliament meets or a state legislative assembly meets. These questions rise in the mind of the people because somewhere at the back of the mind they feel, having remunerated them, are they putting back full to the system?
I'll also add to this. Urban areas, the situation may be different, but in rural areas, the representative, whether it be an MP or an MLA, is also seen as a service provider to the huge number of voters there and the citizens of that constituency. So right from health, right from clothes, all welfare measures, he is the one who's held responsible for it and he is the one who's expected to deliver. So 5 years, that also needs to be kept in mind while deciding their salaries and perks and other things. I'll straight away toss the subject to the audience. Yeah, questions?
Good morning, everybody. My name is Anu Mishra. I have a question to the legislature. Ma'am, don't you think that there is a requirement for an independent committee? Because we've been talking about committees which establish the basis of salaries, but then again those committees are formed by members and then therefore there is a conflict of interest. So don't you think there's a need for an independent committee?
Yes, there is a need for an independent committee because if you see, there usually is if you look at the record, there's usually a consensus among all party members that yes, the hike, there is no opposition there because as you see that it is all self-decided and so they would decide their own cause in a sense. So there should be a committee which is absolutely independent. There should be experts on this also from the other commissions as well who look into all these parameters and come to a conclusion whether this remuneration is right for a particular member of the assembly or parliamentarian. And definitely it should be looked vis-a-vis the scrutinized vis-a-vis their output, that whatever they are doing, they are here for 5 years, they are given monthly salary, this remuneration. Are they performing to the optimum, whether they get a second term or not, but are they doing what they are doing? And as Honorable Justice Qureshi said that yes, they are looking at the performance. If the parliament was to function as it was supposed to be in the assembly and they were doing their duties, this question would not arise in the minds. So that is the crux of the whole matter. So there should be an independent committee, there should be experts from all kinds of fields, and then they should come to a decision when they decide these issues.
Next question.
Prachi Panchal. Ma'am, my question is to the legislature. Ma'am, don't you think the salaries and allowances should be linked to the performance linked salary system?
Yeah, if you're following
Yes.
the salary pattern, why not link it to performance?
Definitely, I think public service, I mean the people who are getting elected, they are getting elected on that one particular point, that we are here to do service for to the people of this country. That is the sole objective. And the people give votes to them because they're sending them as him as or her as a representative. He's going to put our case there, and so that performance is the hallmark of the whole thing, it's salient feature, I would say. And so that is why the committee should look into that as well. But then there are several other factors which would come in when you're talking about performance of a particular person there. So it's a very larger issue as well.
Vyas sahab, you would like to add on performance? Because I would like...
परफॉर्मेंस का तय करना बहुत मुश्किल होगा, परफॉर्मेंस तय करना बहुत ही प्रॉब्लमेटिक होगा. और दूसरी बात ये है कि डूइंग समथिंग एंड एब्स्ट्रैक्टिंग फ्रॉम डूइंग समथिंग इज ऑल्सो परफॉर्मेंस. सो डूइंग परफॉर्मेंस और नॉट डूइंग समथिंग इज ऑल्सो परफॉर्मेंस इन द लेजिस्लेटिव और असेंबली मैटर्स. सो इट विल बी डिफिकल्ट टू डिसाइड सम परफॉर्मेंस मेजर्स और some metrics for that.
Sir?
It's an excellent question.
Yeah.
I do not think the question is wrong. I only think that there are no manageable standards of finding out the performance. What would you call performance? One who attends the maximum number of days, one who asks the maximum number of questions, one whose people in the constituency feels he is the most popular. The pay commissions after pay commissions in the central government have grappled with the idea of linking the pay with performance. They have not come up with a formula. We hope they come someday and your question would be answered.
That's all we have time for in this segment. We'll be, after the break, we will discuss Article 123, that is, power of the President to promulgate ordinance during recess of Parliament. Welcome back. You're watching Constitutionally Yours on Rajya Sabha TV. Now we'll take up Article 123. This is the power of the President to promulgate ordinances during recess of Parliament. Not just this government, but even earlier successive governments, all of the governments have taken undue advantage of promulgating ordinance. Now it has kind of, it has become a sort of a reason with ordinances that if you're having problems implementing certain ideas, and if it doesn't have the approval of both the houses of Parliament, then this is the way out. But the reason for ordinances were completely different. The reasons why these powers were given were completely different. Yes, ma'am. Do you feel that the undue advantage taken by the executive, the government, of promulgating ordinances is not the right way to go? Not just this government, but earlier governments have also misused it.
No, all successive governments, earlier governments have taken the ordinance path many times, and we may not blame a particular government, but this has been put there in the constitution. The wisdom of the framers of the constitution was that when there is certain urgency and the parliament is not in session, during that recess, the Honorable President can promulgate an ordinance, and then it of course has to be again put before the houses, and then it should have a retrospective effect. But that was only for some urgent, immediate action required, and not by way of some kind of a normal routine which has of recent become the trend because the parliament is not functioning, because the two houses don't come together. And so I think that that emergency powers, in a sense, that urgent powers need to be there for ordinance route.
Mr. Vyas?
Yes, there are 2-3 elements there in Article 123 and Article 213. So one thing is urgency. First thing is that Parliament should not be in session, and third thing, circumstances exist which requires Governor or President to take immediate action. These are the three things, and Governor or President is satisfied. It is subjective satisfaction of the Governor or the President. So it not be questioned whether his satisfaction is just or not. It cannot be questioned in the court of law. So these are the powers, extraordinary powers, which can be used in emergency and urgent circumstances. It is just and right.
Sir, although the judiciary doesn't have the power to really intervene or do anything about this, but the way it was designed and the attempt of it, is that what is happening nowadays? Because there are various other reasons for bringing in an ordinance, not necessarily the reasons that are listed.
Mr. Rai, briefly, these powers are not there in all constitutions. In Indian context, it was realized at the time of framing of the constitution that there may be emergent situations where both houses are not in session and a law is required to be made. So these powers are given with two safeguards. One, the President must, with the aid and advice of the Council of Ministers, realize that there is an emergent situation, and two, both houses are not in session. With that, it is a classical example where an executive takes a role of the legislature. The Council of Ministers makes a law. A law which is made will endure till it is either withdrawn, disapproved by the Parliament, or not put for 6 weeks or not approved for 6 weeks.
Right.
And the damage or the effect will be felt even if it is either disapproved, withdrawn, or lapses. Therefore, these are extraordinary powers.
Right.
It is not correct to say that they have never been misused. In Vadva's judgment, Supreme Court noted that in state of Bihar, there were 69 ordinances which are promulgated, where had a life ranging from 1 year to 14 years. And this is a completely colorable exercise of powers. And Supreme Court struck it down. But the powers are needed. The frame of the Constitution have recognized that. They are being used once in a while. They may even be possible of diverting the democratic process.
I'll pass on to the audience.
Good morning, everyone. I'm Nidhi Tiwari, and my question is to you, ma'am, to the legislature. Now, regarding the promulgation of an ordinance, it is done by the President on the aid and advice of the Council of Ministers, and there is absolutely no rule of the opposition. So don't you think there should be adequate representation from both the sides, from the government and the opposition, so that the exercise of the power can be checked?
Very good question, yes.
If that was so, well, if you see, for want of the consensus of the other party, the opposition, or consensus from the upper house or the Rajya Sabha, there is no act at that point of time, and that is why when the Parliament is not in session, the ordinance route is taken. And so, well, if that was so, there would be no kind of a ratification, I would say, because it is put back again after 6 weeks and then taken a retrospective effect. But the opposition does not allow these acts or these laws to pass for several reasons, because their input is not taken into consideration, whatever they are asking from the ruling party is not considered, and so there is a logjam. And that is why this situation arises. And so in order to not have this situation, the Parliament is required to function, and that is how the ruling party and the opposition party have to come to a consensus. They have to sort out their odds or whatever their issues are, and so that this ordinance route becomes of use only rarely and not by way of a routine which has happened these days.
Mr. Vyas, the question I would like you to address is, I mean, if the gestation of the ordinances have to be long, what's wrong if the opposition is already taken into confidence and consensus is created before the ordinance comes? That way, the chance of ordinance, even if the Parliament doesn't pass it, of surviving will be longer. Is that a possible good suggestion?
इसमें यह बात है कि असेंबली का सेशन मिलता है, उसके बाद उस डेट से 6 वीक्स तक उसकी लाइफ रहती है, मगर अगर ऑपोजिशन और गवर्नर हिमसेल्फ ऑपोजिशन उसको ऑर्डिनेंस को नाबूद करने के लिए रेजोल्यूशन पास करती है, तो 6 वीक का टाइम ज़रूरी नहीं है, फर्स्ट वीक में ही वो इट विल बी डूम. और other alternative is that if governor himself withdraws the same thing, then it doesn't survive for 6 weeks long. So these are the two situations there.
Sir, you would like to add?
Mr. Rai, when a law is made through ordinance, it does one thing. A law is passed without any parliamentary debate. Secondly, it also has a power to promulgate law with retrospective effect.
Correct.
It will cover a period when the parliament was actually in session and did not legislate. And the governor or the president of the center, when advised by the Council of Ministers, can say the law will operate from 6 months back when the parliament was in session.
Right.
So these are the powers which are to be exercised in extremely, really genuine urgency and not to scuttle or avoid a parliamentary debate.
Next question.
Good morning, sir. Good morning, ma'am. My name is Shivansh Jolly. My question is addressed to the judiciary. Sir, while considering the DC Vadva versus State of Bihar case in 1986, even though it was held that repromulgation of ordinances should not ideally be done, an exception was laid out. Now, due to that exception, we saw in 1990s 53 ordinances being repromulgated. The same has also happened in this government scenario at the center, the land acquisition ordinance being repromulgated again and again. My question is, sir, is there a need to revisit the DC Vadva case to strike down that exception entirely?
With respect, no. Powers are there, and powers are meant to be exercised in in correct situations. At the same time, be it on the legislative or be it the executive, our constitution recognizes certain checks, and judicial check is not the only source of such checks. A political check. The people of the country should question these actions, because in every case which goes to a court of law, it will take 1, number of years, 2, it will be a case specific judgment. This was correct or not correct. If the whole trend is wrong, the people should correct it.
Next question.
I'm Srishti Vaishnav, and my question is addressed to the judiciary. Sir, it is settled that the ordinance should be promulgated only when there is immediate requirement to do so and not to meet the political ends of the ruling party. But however, the Honorable Supreme Court has also held that subjective satisfaction of precedent should not be challenged in the court. So, in the light of these two precedents, my question is, what should be the scope of judicial review so as to control the promulgation of ordinances?
You see, the question of the satisfaction of the precedent of emergency is not about judicial review. But there is an increasing trend that very few issues are left outside of the scope of judicial review. In Bomai's case, the Supreme Court expanded these principles. On the question, specific question of the precedent's satisfaction also, it has been held that it's not a political question. Only political questions are kept out of the judicial review. And therefore, if the precedent's satisfaction has been achieved wholly mala fide or wholly on basis of extraneous considerations, or it simply cannot be justified, the court can step in. But as I said, the court can step in on case-to-case basis and not on a general trend basis.
Next question.
Good morning, my name is Samiksha. My question is to the judiciary. Since the effect of an ordinance is permanent even after it fails, does it not mean redundancy of the parliament in some way?
Ordinance makes a law, and you are right, it makes a law whether it is approved or disapproved later on, it remains as long as its effect was felt on statute book. But it also has the same limitation as the powers of the parliament to make a law. Therefore, through ordinance you cannot make a law which is repugnant to fundamental rights. Through ordinance you cannot make a law which is otherwise not within the competence of that house, be it state legislative assembly or the parliament. On that ground, it can also be challenged the same way a law made by a parliament or a state legislative assembly can be challenged. But you are right, a law which is made by the executive, which is later on not approved by the parliament, may still have effect which will be permanent for that period.
Mr. Vyas, you would like to add to this?
Yes.
Overlooking the debating activity, the powers which are there inherent in the parliament and the assembly.
ये पार्लियामेंट में और विधानसभा में उसको ले करना पड़ता है कंपलसरी ऑर्डिनेंस को, और ले करने के बाद उसका डिस्कशन होता है. जो एग्जीक्यूटिव ने एक्शन लिया है ऑर्डिनेंस करने का, वो इट इज़ आंसरेबल देयर, इज़ रिस्पॉन्सिबल देयर. गवर्नमेंट इज़ रिस्पॉन्सिबल एंड आंसरेबल देयर ऑन द फ्लोर ऑफ द हाउस. So it is not like that. It is subject to scrutiny of representative of the people and house itself. So there is one check is also there. If government is not going to replace it by legislation of the house, then also it is power of the house to discuss the matter and discuss the ordinance.
Ma'am, you would like to add something to it?
See, if we are talking about this ordinance, in a way it is kind of, I would say subversion is a little stronger word, but you are taking another route. When that main route is available to you and you have not been able to exercise that despite having all the factors there, and still you have to go the ordinance way, definitely it has some kind of a suspicion attached to it, in a sense. I am not saying in its exact meaning of the word suspicion, and that is why all these factors do weigh when it comes back and still doesn't act as a law. So it remains, as you said, as it is, and you have not been able to exercise your rights, or you are put there by way of a legislator that you are supposed to make a law, you are sent to the parliament to make law, and you are not doing that activity itself, and still you have to take another alternative way. So it's time that we look into this as well.
Thank you very much, sir, ma'am, and the audience. This was a fantastic discussion. We'll be back with a new episode and in a completely new premises, a new High Court. Keep watching Rajya Sabha TV.